copyrights. We need to discuss how copyrights are assigned and registered, and how your work agreements determine whether you or your employer or your client actually own your design work. The ownership and right to exclusively earn income from creative work is legally protected and transferred by copyright, trademark, and patent laws. Let's first start by defining intellectual property. Intellectual property is not a law per se, but a group of laws and legal concepts that deal with who owns and has the right to profit from new creations, art, inventions, books, photographs, and then for how long. Intellectual property is what is created in the mind, in your mind, in my mind. It's a group of laws and legal concepts that deals with who owns and has the right to profit from new creations, and it sets the legality of how works can be used, traded, and transferred. An example of intellectual property you see in your daily life. Anything from technology to things in the automotive industry, food, the music industry, and the film industry. Intellectual property has different components: copyrights, derivative works, infringement and fair use, and trademarks. Let's start with copyrights. Copyright. The creator of a new original work is granted copyright, an exclusive legal right to profit from their creation. So concepts and ideas cannot be protected as original work. General use items, such as the color brown, cannot be copywritten. The copyright laws give the creator exclusive rights to take advantage of their creation. The basic concept of copyrights actually evolved from the 17th century English royalty, and it is spelled out in Article 1 of the U.S. Constitution. I do want to make a note that from country to country, copyright laws and regulations are different. So the U.S. copyright laws do not work in France or Mexico or India. So that's something to think about. The first area copyrights protects or grants is the reproduction of work, the ability to duplicate and or sell the work. Adaptation, like taking a book and turning it into a movie. Modifying the work, and this is a really fine line between inspiration and infringement, and it is very easy to cross. You have to be cautious. And then the ability to make derivative works. Derivative works are works that derive from an original piece. You own the copyright at the point your new creative work is completed or fixed, whether you register the work or not. Couple of important key pieces here. You must register the work to bring an infringement suit to court. Although copyright protection begins as soon as the work is created in a fixed, tangible medium, your strongest legal position is established when you officially register the work with the Copyright Office at the Library of Congress. You must register your work to receive any potential statutory damages. An idea of a statutory damage would be terms of lost revenue. Statutory damages assign an amount per work, which in most cases are around $150,000. Next question many people ask: does the copyright notice need to appear with your work? Although most legal professionals will advise, they'll strongly advise you to do this, you don't have to. So it's strongly advised, but not necessary. An infringing user of the work can claim, however, that they were not aware of your copyright. Typically, the C in a circle is the widely used symbol, but it is not actually an official symbol. So many times it might say copyright notice and then your name and a date. Or it might have copyright or the C in a circle, plus the artist's name or an abbreviation, plus the year or the date of first publication. Now, the natural author of a work is granted copyright for 70 years after death. If the work was created for a company, which we call a work for hire, or otherwise has a corporate owner, then the copyright is good for 90 years from date of publication, or 120 years from creation. So 90 years from date of publication, 120 years from creation. So these terms were all extended by 20 years with the Copyright Term Extension Act of 1998. This was done to protect several well-known copyrights, like everybody knows Disney's Mickey Mouse character. Actually, Disney's Mickey Mouse character would have become public domain, though still protected under trademark of the Walt Disney Company, without this extension in place. So copyrights that were created after January 1st of 1978 have the life of the artist plus 70 years. There's the Bern Convention of 1886 in Bern, Switzerland, and this convention provided for a term of 50 years after the publication, which means the work has been lawfully made available to the public. However, if the identity of the author becomes known, then the copyright term for known authors 50 years after death. Copyrights have changed throughout the years, and it really is in your best interest if you're looking at a piece that you think is open and the copyrights have been lifted, you need to see when the date of creation was or when the date of publication was to see if someone really does still own copyrights to that piece. Portfolios and copyrights. Pieces in an artist's portfolio should have a copyright notice on them, including the published pieces when the artist has retained the copyrights. The term infringement that we have used already just means, individual company or an individual uses a copyrighted work without permission of the owner. Derivative work, as we have mentioned also. Derivative work is defined along the same lines as the copyright holder is entitled to make derivative works of their original. So the copyright holder can make as many derivative works as they want. A work derived from original copyright work would be something like a sequel to a film, a limited edition poster series based on an original illustration. So there are some derivative works out there, and the question always is, what percentage needs to be changed to be acceptable for use? The Happy Birthday song, copywritten. Up until recently, where those copyrights have expired. Fair use. Fair use is a legal term for using copyrighted work without permission, but in a manner that is allowed because the infringement does not rise to the level of harming the original work. There are 4 legal tests for fair use. Those tests are what the courts use to determine fair use of copyrighted work, and they are the nature of the original and infringing work. So, could it be coincidence that your work looks like, sounds like, or otherwise appears to be similar to the alleged infringement? Does the new work transform the original work to a new meaning or art form? And then the level of creativity, and this is the key focus. The second test that's used in the courts is the purpose. Is the work intended to be directly competitive to the original? Parody, protected by law as free speech. So this is the one that will usually become your defense in an infringement case. The point at which a parody is as similar to a brand as to create customer or consumer confusion or to devalue a brand name, then it crosses the legal line and you lose that parody protection. The third test used by the courts is the amount of work used in the infringement. So the core thing that makes the work unique and desirable. It's the heart of the work. If that so-called heart is found in one line of a 200-page book or 10 seconds of a 2-hour film, then the courts actually could still rule the use as infringement and not fair use. The fourth test that the courts use in determining fair use is the effect on the market for the original work. So if the infringement can be seen as lessening the demand or the opportunity to earn revenue from the original work, then there's a stronger legal case. In a digital copy, the duplicate is exactly the same as the original. Having millions of copies of equal quality in circulation substantially damages the value of the original file. Probably the easiest here to understand is with the music industry. Typically, we summarize fair use as criticism and comment, news reporting, research and scholarship, nonprofit educational use, and parody. And this is where we, in the education environment, can use copywritten material. However, the question becomes, if you're doing an assignment and you use copywritten material, you end up placing that assignment in your portfolio. Did you just break the copyright laws? Is that portfolio intended for any kind of profit? If it is, then you did break the copyright laws. And so that's why we are so concerned with any piece that goes in your portfolio that it really needs to be copyright free. You need to own the rights to all of those pieces. The Conference on Fair Use final report was in 1998, and this is what was documented as fair use. 10% or 1,000 words, 10% or not more than 30 seconds of a musical work, 10% or 3 minutes of a motion picture, an entire photograph but not more than 5 images by the same creator, 10% or 25,000 fields from a database.